constitute administrative action. Within the meaning of Article 47 of the Constitution and Section 4 of the Fair Administrative Actions Act. And so is the process of plea taking before this court. Those processes must be lawful, reasonable, and procedurally fair. That the police have purportedly commenced and concluded investigations in support of the deferral. That's Mr. Eric Theory.
Directive or instruction?
It's a directive. He's now the boss. I used to be the CEO, but now he's the president. So he directs all of us, including Professor here. So he has directed me to inform the court that the Law Society be put on record in support of the deferral of plea, and that because he is away in Kisumu, he will address the court comprehensively on the dates that the court will give upon successful deferral of the plea. Your Honor, finally, since
Just a minute.
Finally, Your Honor, since my colleague Ongwaya has addressed you on most of the issues I have not detailed, I only want to inform the court on the gravity of what is before you today. Your Honor, your court and you personally is being called upon to interfere with the administration of justice in a superior court, ELC, in the matter that Ongwaya has addressed you on, that is ELC number E242 of 2022. That is what is before this court. Your Honor, as a judicial officer, fraud at this attempt for you to be used And the person who is attempting to use you, Your Honor, because now we have to say it, from the letter that has been brought before you, is the Deputy President of the Republic of Kenya. We must remind the Deputy President of the Republic of Kenya that things don't work like that. The matter in the Superior Court must continue on 21st and 22nd. And he must subject himself to that court. And not run using state apparatus to come and use this court to interfere with the administration of justice. Your Honor, refuse to be used. I submit. A cautionary statement from Mr. Ward. As we speak today, the police have never taken fingerprints from Mr. Ward. Mr. Ward received no prior notice to be in this court today for his own defense. The copy of the draft copy of the charge that the prosecutor has very kindly given me, and I appreciate that gesture on the part of the prosecution. I hope it's the same copy that you have. I want you to look at it. Are we there? If you look at that charge sheet, that row, which says if arrested, then it starts date of arrest, with or without warrant, date of apprehension. I'm going to the second last column, bond or bail and amount. You notice that accused 1, in custody. Accused 2, apply summons. Accused 3, apply summons. Even at the time of preparing this charge sheet, the prosecution didn't anticipate to have the third accused here. The instructions were that summons be applied for. This confirms all that I have told you. You know, this mode of processing a suspect to become an accused person is unconstitutional. Where you become an accused person by chance, that you happen to have gone to the basement to your client. It is not anticipated by Article 49 of the Constitution. I dare say
My Lord.
Your Honor.
Your Honor. Yeah, we hope that becomes prophetic. Becomes prophetic. And that's what Mr. Ward is privileged that he is an advocate and therefore can get legal representation on the notice that the police and the state gave him, which is no notice at all. I'm aware of my ethical responsibility not to vouch for clients. He was my student and a good one at that. But our constitution anticipates that Mr. Ward, if he has to be arrested as happened this morning, would be informed of the reason for his arrest. I must tell you, madam, we didn't know the reasons for his arrest until I got a copy of the charge sheet from the land prosecutor while sitting in court. We didn't know. So, Your Honor, why must this plea against the third accused person be defied? I use the word must advisedly because it is reprehensible for any of us to imagine we can be taken through this. This man left home this morning, told his wife and children he is going to earn a living. He may return in the morning, in the evening, sorry, with whatever morsel he would have retrieved from his quest for a living. And just like that, those people may never understand what happened. No prior notice given to him. I said, Your Honor,
Just a moment. How many more minutes will you take?
may I plead for just another 10 minutes?
I can see you can go on up to...
No, I just plead for another 10 minutes to make this point, because I'm now coming.
My name is Urina for the first accused person. And if you
I have considered the submissions made with regard to application made by the Defense Counsel for deferment of plea. The issue for determination is whether there is good ground for deferring of plea taking in this matter as sought. And the Defense Counsel relied on the provisions of Article 49(1)(g) of the Constitution, which is submitted provides for 3 options: for an arrested person to be informed of the charge, to be informed of the reason for detention continuing, or to be released. The first and third accused persons herein have already been charged. A copy of the charge sheet has already been provided to the Defense Counsel. The main reason being advanced by the Defense Counsel for the first and the third accused persons is that Miranda rules were not complied with as at the time of arrest of the third accused person, and that arrest of the third accused, who is an advocate, is intended to secure an adjournment in ELC case number E242 of 2022, which is scheduled for hearing on 26th. of June 2023, and that the first accused is also a witness in the said case, that count number 7 relates to alleged actions of the third accused person in his capacity as an advocate in the said Environment and Land Court case, and that the arrest and charging of the third accused person is an affront to administration of justice. I have gone through the charge sheet and noticed that count number 7, complained about by the defense counsel, is closely related to count number 2, where the accused persons are jointly charged for making document, which is also mentioned in the particulars of offense to count number 7, without authority. In my view, it is not appropriate to go into the merits of the case even before plea is taken. The charges are, from my reading, closely intertwined, and therefore, whether or not the third accused was acting in his capacity as an advocate, and whether the alleged actions outlined in the particulars of offense are privileged, cannot be properly determined by this court at this stage. Otherwise, the impartiality of this court may itself be called into question. The submission that the accused persons before the court, that is the first and third accused persons, are active participants in the Environment and Land Court case number E242 of 2022 as a witness and advocate respectively is not disputed by the prosecution counsel. I do not see how taking of plea in this matter will hamper administration of justice in that other mentioned case, because the first and third accused persons are already in police custody, and whether or not plea is deferred, that fact will not change. I have carefully considered the submissions made by both sides, and I am of the view that proceeding to take plea in this matter will not in any way hinder any of the accused persons from challenging legality of these proceedings before the High Court. They can do so regardless of whether or not plea will have been taken. However, justice must not only be done, but must also be manifestly seen to be done. The defense has raised questions regarding the circumstances of arrest of the third accused person at the basement cells where he had gone to talk to his client, the first accused, and immediately brought before this court to take plea. The law provides for expeditious administration of justice, but there should be no hurry to an extent that questions then arise with regard to fairness of the process itself. The case has been filed today. It will not end today, so deferring plea will not occasion any injustice to neither the prosecution nor to the defense. Considering the totality of circumstances, and in order for the court to be manifestly fair to all sides, it is appropriate that the application for deferment of plea taking be allowed, and summons requiring attendance be issued to the second accused to appear before this court for plea taking on the date to be allocated in this sitting. Plea shall therefore be taken on 29th of June this year. In the meantime, each of the first and third accused persons herein is granted personal bond of Kenya shillings 1 million without surety, and these bond terms may be varied after taking of plea on the scheduled date. Orders accordingly.
Most obliged, Madam Mayor, most obliged.
Unless the prosecutor has a protest. No, it's good. It's good to hear protestations inside here than hearing of them in another forum.
We shall abide by the order of the court.
I told you they are good men.
Thank you. So we can have a lunch break.
Yeah.